morning. Are you Anthony Mendoza? And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated furthermore. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections to that report? All right, Mr. Parker, you may proceed.
Well, a couple things on this. Switch out before you get there. In order to have scram and it's costing $6 a month. Having to go to work, but you not to job. Yeah, the job we don't like.
Here, the defense is painting a picture we've heard before. Probation costs piling up, device fees hitting $600 a month, and a man stuck in a catch-22. Can't work without driving. Can't pay without working. But remember, these scram and interlock devices aren't punishment. They're a privilege instead of prison. When you violate that trust, courts take it personally.
Able to work and can't afford to pay the things, you know, the excuse of 12-step program, the GD program, all those things. So, that's one of the issues. But more the thing I'm concerned about is that some people work the same to do that program. I'm not sure if whatever you never done. I don't know if he was going to go and didn't go, but I think he's contested at the time, and I'm not sure how that happened. But he also said he's never tested positive for something to the election. There is the addresses issue that currently have with one facility came that way. Also, turns the fact that hands like you felt sore, his ankle, so you took the stop behind the screen fight, and in this incident, he was frustrated. He wanted to take his boot off the show, and the director of the problem was there. When they came, he was disrupted. He has no other felony telling the judge, and he wants opportunity for that. He has stage probation. He wants to be the same relapse. I'd like to hear what you say and what happens now. He also.
Well, let me first make sure I've got the timeline because it appears that I see that safety he completed and then was placed on zero tolerance in the high medium caseload. And after that, there was an issue where he was testing positive against alcohol and cocaine, which I understand he denies cocaine, but that's what's alleged. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safety. Yes, there was a motion to allow anyone for So he wasn't in custody. Okay. Then, so we didn't see him again until August 11th, 2023, when he was arrested.
And right here, this is where it all starts to crumble. The judge is laying out the timeline like a prosecutor. Missed programs, failed drug tests, and new arrest for aggravated assault with a deadly weapon. When a judge starts summarizing your mistakes chronologically, trust me, it's not going to end well.
Houston. So here's the thing. You probably didn't get any paperwork. Come up here to the front, in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here, and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. Gave you upfront time, continued you on probation. Courtesy supervision was sent to Harris County, and then we have scram device issues still, alcohol violation, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own because you didn't know about it because you weren't going to safe. Mr. Nichols?
Yeah, it's still on zero tolerance. We should we are
Third.
multiple times.
Yeah.
What else is good? Obviously, we have probation terms, cancer. In fact, there's one thing I want to left because Martinez.
Yeah, sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Now watch this. The moment that seals the deal. The probation officer testifies that when told to turn himself in, Mendoza's only reply was a single word. Ha. That's right, huh? Imagine emailing your probation officer that. At that point, you're not just breaking the rules, you're mocking the system. And judges never forget that.
Thank you. Go ahead. Yeah, just fine.
Oh, he's already applied.
It's admitted.
Use that.
Any questions?
Just a couple. I want to clarify on the relapse program. You said y'all can put a load of Revokes down on my team. And so the state that we have 4 and 5. Yeah. You know, what do you have to do?
The hearing was completed on the top. She was going home where he right everybody for the general lack and for that the hearing that kind of just in all of the for alcohol and cocaine the supervisor that happened like that she will warn. Those are the right words. Voice or warn.
Let me get a question.
Thank you, Mr. Martinez.
You see more than this quarter, we never.
Sure. Go ahead.
You want to go to court?
Nobody's saying you went to safety twice. We're saying you went to safety. Hold on, don't listen. I'm going to let you talk, but don't talk over me. We're saying that you went to safety and then that you were ordered to go to the safety relapse, but you never came and turned yourself in after that phone call where you were told there was one. So no, you never went to safety relapse. Go ahead.
Those confident denying when I got years ago, top, just trying to work, yes, I'm
Okay.
so I'm going to
Right. So did you respond that you emailed? That's what you thought about all that? You thought that was funny?
The tension here is thick. Mendoza's excuses clash with the judge's frustration. She's had it. This is the part where justice turns personal. Listen closely. Her tone isn't just legal, it's emotional. She's not just sentencing a man. She's expressing years of exasperation over wasted chances. 6 years in prison, and you can feel that hammer drop.
Well, you had money to buy alcohol. You had, because you kept drinking, because you kept Mr. Mendoza, you have been given so many opportunities on this probation. And I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long. The reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. Seriously, you got the initial probation in 2021. You got relapse. You got safety. You got upfront time because of the Harris County issue. Didn't revoke you. Have revoked you 3 times. Haven't revoked you. And here we are with all of these violations. Well, how old are you? How old are you? 43 years old. That doesn't mean anything. You have this felony, and you have 6 years hanging over your head. And you've been given all the tools. You went to safety. You got aftercare. At some point, you have to take those tools and do for yourself, and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools. We're done. We're done. No, we're done.
And just like that, the gavel falls. 6 years behind bars. No deals, no leniency, no more excuses. The lesson? Probation is a lifeline, but if you pull too hard, it snaps. The system will give you chances until it doesn't. What do you think? Was 6 years fair, or did Mendoza deserve one last shot?